You're live.
Hey, good afternoon and welcome to the Legislative Committee meeting of the Commission on Ethics and Lobbying in Government. My name is Dolly Caraballo and I am the chair of the committee. We are joined by the other members of the committee, Leonard Austin and James Karras remotely. And I'm going to let Director Berlin's say how we feel.
Thank you, Commissioner. This meeting is being held pursuant to notice and in accordance with the provisions of the state's open meetings law and the Executive Law Section 94. Both the conference room we're using at the Commission's offices in Manhattan at 25 Beaver Street and the conference room at our offices in Albany at 540 Broadway are open to the public during public session. I should note that Commissioner Karras, as Commissioner Caraballo mentioned, is participating in this meeting remotely by video conference, and that's pursuant to Public Officers Law Section 103-A and the Commission's rules and resolutions for remote participation on account of extraordinary circumstances. And I can state that a quorum of the committee is present here at the Commission's Manhattan offices.
Thank you. I also want to thank the commissioners who are joining our meeting. Is Commissioner Vice Chair Ayers with us, or is she joining us?
She had been.
She's expected to join us.
She was on. She was.
Sorry, are you asking about me? I'm just muted because my dog is barking ferociously.
I am asking about you. Yes. Yeah. Okay.
Ah,
So yes, thank you.
Looks like a ferocious dog.
now we have a
So
quorum plus. We're good.
I am pleased to say that as reported in the news and by the director, at least two of our legislative proposals are
Advancing.
under consideration, at least in committee.
Correct.
And that's the
Electronic.
electronic.
Right, requiring electronic filing for all lobbying submissions and the Commission's proposed amendment to the open meetings law with respect to advisory bodies, committees, subcommittees of commissions to modify the personal presence requirement. Those are advancing, at least in committee, in both chambers at this point.
Yeah, the OML one passed the Senate committee this week.
Yeah,
So
it's on the Senate
I think
calendar.
it's onto the rules committee.
No. It's on the Senate calendar.
Okay, I stand corrected. It's on the Senate calendar. And then
In the Assembly, it's in committee.
it's in committee, correct? And then the other one that having to do with the electronic lobbying filings, that passed the full assembly. So out of committee, full assembly passed, and it passed the Senate committee and is on the calendar in the Senate.
That's great. Thank you. So we're meeting today to discuss a number of different proposals that are before us. One is to codify sexual harassment through a regulatory amendment. And the second is a proposal by Vice Chair Ayers to add a 10th proposal to our legislative agenda that would change the voting requirements needed for the commission to act. And so I think we'll start with the regulatory amendment. Everyone received the memo did everyone receive the memo from Director Berlin on the proposal?
I can't hear.
It was provided to everyone.
Okay.
I
And
can't hear.
I'm sorry, I'll talk louder. And does anyone have any questions about it?
Okay, got it.
Does anyone have any questions about the memo?
This is the sexual harassment stuff.
Yes. So we have had a proposal to codify sexual harassment on our legislative agenda for several years, and it has not gotten any traction. And so we started discussing late last year the possibility of doing a regulatory amendment. Director Berland submitted or circulated a proposed regulatory change, and I edited. I don't know if everyone got my edits. Do you know?
I believe it was circulated to everyone. I've handed
Oh,
out
let
a
me
hard
see.
copy.
It
Okay.
didn't come out as a red line though.
This one?
Yeah, it didn't, on my computer.
Oh, yeah, okay.
It was a red line.
I can have,
Well, this one did.
Oh, but not on the computer.
Okay.
So, so what we want to discuss is whether the committee and members of the commission who are here, whether we would recommend adopting this language for regulatory amendment or putting it out there for public comment.
to commence a rulemaking.
Yeah, to commence the rulemaking process. You want to talk about the rulemaking process quickly?
Yeah, I mean, the rulemaking process, essentially, is the commission would initiate the process. We would have the proposal published in the state register, and we'd have a period of time for public comment, and then it would return to the commission after approximately 90 days to consider whether to adopt the regulation permanently, subject to whatever modifications, if any, it deems fit, and taking into account any comments received from the public.
Thank you. Thank you. So,
And I should say, in terms of the draft, the goal of the draft was to clarify and to capture existing practice, both of this commission and predecessor commissions, in interpreting several subdivisions of Section 74(3) of the Public Officers Law, which have been applied to sexual harassment enforcement proceedings in the past, specifically subdivision H, subdivision D, and subdivision F of POL 74(3), depending on the nature of the conduct involved, and that's laid out
in this,
specifically in verbatim in the draft.
so just to refresh for a second, our legislative proposal was to add a new subdivision, right?
Correct.
The
It would add a new
proposals, add a new subdivision 74(3)J, which would specifically prohibit sexual harassment. In the the commission is authorized to change regulations that affect the public offices law, and so that's what this proposal is. And the way you guys set it up is to add it to add a new part 940, and I'm suggesting that it be called clarification of sexual harassment as a violation of the Public Officers Law, Section 74(3), H, D, and F, rather than the way you proposed it. Does anyone have any questions about that or suggestions or
I
thoughts?
don't agree.
Okay.
If I may, I don't agree calling it clarification. It's just,
Okay.
if we do it, it's now what it is. It's not clarification of anything.
So the reason I wanted to change it to clarification is that there's another regulatory amendment that we did for lobbying, and that was called clarification of the responsible party in that statute. And so I was kind of modeling that, what we did there. But the other thing is that this is really nothing new that we are adding technically. We've always had, we always interpreted these provisions to include a prohibition against sexual harassment. So for me, Len, the reason I'm calling it a clarification is because it's been here. And so all we're doing is clarifying. Of course, we can decide that as we move along during the meeting. But that's the reason that I did
Is
it.
there currently a part 940?
There's not currently a 940 part 9. So this is new.
So there's nothing to take, we're just making our first stab at it.
Right.
I don't think it needs clarification since there's nothing unclarified from before. We're jumping into the water for the first time.
Does anyone else have any comments about calling it a clarification rather than just the sexual harassment violation?
Dolly,
I guess I do, if that's okay.
Yeah, of course.
I just wanted to say, thanks. I don't mind much what the title is or anything like that, but I do think it's important to be clear that this is not a new, this is a codification of an existing interpretation. It's not, we're not creating a new interpretation. This is my understanding. It's certainly true anyway that staff's understanding has consistently been that this is the meaning of the law. And I think when we've adopted the legislative agenda proposal, it was on the understanding that we were seeking a clarification of the law, a confirmation of our view, rather than that we were seeking to add a new prohibition into the law. So I guess that means I support being clear in what we say, that this is not a new interpretation. We're not saying that this is a change in the law that governs the conduct of people who are regulated under these rules. This is codifying an existing interpretation. Of course, the commissioners have only sort of adopted that interpretation in the sense of voting for the legislative agenda item, which was premised on that understanding. We haven't done any other formal interpretation of the law, but I do think it's a good idea to be clear that this is not sort of a new conduct rule.
Thank you. Chair James? I think you're muted.
I agree that we need to make sure that it's understood that this is not a new rule. Although I think I share Commissioner Austin's view that we, rather than not to call it a clarification, because we don't have anything in there currently on it.
Correct.
And we are actually defining what sexual harassment is. So it's a new regulation.
Correct.
So I think I would be comfortable without calling it a clarification, but I mean,
Yeah, now that you said that, I agree. I'm sorry, go ahead.
I mean, if the sense of the commission is, of the commissioners at our full meeting, is that they want to interpret it, use the term clarification, I'm fine with that, but I don't know that it's necessary in this context.
If I might interrupt, this is St. John here. Yeah, because to the point, we're not clarifying as we did in the lobbying context.
Responsible party, I get it. Yeah, as soon as you said it.
Yeah, we're not clarifying an existing regulation. We're actually establishing a new regulation to clarify our own policy interpretation of the statute.
Understood now, I get it, Lynn. All right, so we'll get rid of that change and leave the section heading as is. I get it, yeah. All right, thank you. Thanks for clarifying for me.
May I ask a question before we go forward?
Sure.
Commissioner Karras circulated a copy of the Maryland State rule. Did that go into the preparation of this, or do we have what other states have done in terms of defining and acting on sexual harassment?
Len, Jen sent me that, I think, yesterday, late afternoon. I think, unfortunately, the way the email was, I think there were 3 attachments, but I think you had to click on something to get all 3 attachments. There were 2 Florida decisions as well. So I'm not sure if everybody got that or not. But I wanted everyone to see it. I thought it was instructive and informative. And I think it raises issues on both sides for me. You know, on the one hand, it makes me a little more comfortable that jurisdictions are doing this. On the other hand, it makes me maybe a little less comfortable about how we're doing it and if we're doing it exactly the right way. So just to, Len, that's what I wanted to say first. I don't want to take the floor from you, and they can get to me later.
Yeah, to answer Commissioner Austin's question, no, the language here in the staff draft is based on New York law. So it looks to the human rights law in New York. It takes into account, to some extent, the New York City counterpart to the human rights law. And also, as explained in the accompanying memorandum, it also considers federal law. But no, we haven't looked at other states. We have our own body of law in New York State that's quite robust, both positive law, statutory law, and case law.
I thought the formatting of the Maryland law was a bit clearer than, but that's neither here nor there.
Well, why? Well, is it clear?
I just, in reading it, I felt more comfortable with that kind of layout. That's
Okay.
not a big deal.
Okay.
Sandy, Dolly, could I
Yes.
ask Sandy a question based on what he was just saying?
Yes, of course.
Sandy, the definition that we see in front of us, you say is it a composition of pieces from a host of other existing laws? Or is this copied verbatim from someplace?
It's copied verbatim from, almost verbatim, not completely. I think we made some adjustments in the legislative proposal. So it follows the legislative proposal in terms of
understand, but
definition of
that-
sexual harassment. Yeah, so the original definition came out of the state human rights law, and it came out of the case law interpreting the human rights law and applying the human rights law. And a little bit of it comes out of, if I recall correctly, the pattern jury instruction.
Okay.
That's used in sexual harassment cases, interpreting sexual harassment.
Yeah,
So those are the sources for it.
So there are multiple sources, and it's this definition, though, as it reads here, does not appear any place except in our draft legislative proposal. Correct?
I would have to go back and look. I think it actually does. I think it's almost verbatim from the recommended human resources statement of sexual harassment that agencies are required to, and now all employers are required to adopt. There may be a word or two changed, but it's pretty much verbatim out of that.
And that's in statute or just in the recommended policy?
It's a policy articulated by the Department of Labor based upon its legislative mandate to provide a model code of conduct against sexual harassment in the workplace.
Thank you.
So the human rights law requires DOL to promulgate model anti-harassment policies for now every employer in
And
the
post
state.
them.
And
And post them in the work.
No.
Yeah. So nobody should be surprised. But, yes, Mr. Broadway?
Well, the only reason I raised that question was Sandy had suggested that we look at the Department of Labor's training, and which I thought was an excellent suggestion. But when I was going through all those materials, I was looking at all the places where out there already it talks about various avenues of redress for people who have experienced sexual harassment. And it talks about first, the agency's policies and procedures that they adopt. Then there's the reference to the state human rights law or Title VII. And to the extent that what we're discussing here is an additional alternative forum, I just wanted to be clear that there was consistency across the various forums so that we didn't have confusion on the part of the public or the affected parties and those who are charged with wrongdoing. That's why I was so curious to understand whether or not there's uniformity of definition.
Yeah, and in fact, speaking of Title VII, the corresponding federal regulation, I've quoted in footnote 2, I think,
Right.
of the revised memorandum.
You did.
Yeah.
But it's not identical.
I'm sorry, I didn't catch the.
I'm comparing two things right now. I'm looking at the definition of sexual harassment in, what is that? The new definition, paragraph H. And then if I look at footnote 2, it's a different definition. I mean, substantively, it may get at the same thing, but it's not identical. And the reason I'm concerned about this is because one of the things the Commissioner of Labor was making clear was that the concept of sexual harassment can mean different things to different people. And the whole point of the law is to put everybody on the same page. And these nuances, I just want to make sure that we aren't doing something within an existing body of state law that could generate confusion rather than promote ethics in the state.
Yeah, and I don't think it's an element of confusion. You know, one should keep in mind that generally the statutes like Title VII in particular, also the human rights law, are talking about employer liability.
Correct.
As opposed to constraints or standards of conduct applicable to individual employees in the workplace. We don't per se, I don't want to go too far in this. We regulate, for the most part, individuals when we're talking about the public officers law. So we're looking at individual conduct, and we're looking at whether or not when we receive a complaint, individual state officers have or have not complied with their obligations, in particular here under Section 74, the Code of Ethics.
But are you suggesting that the conduct that they are going to be held to under the ethics law is the same as the conduct they would be held to under the human rights law, or probably starting where all these cases typically begin, with the agency's policy?
The agencies are required to comply with the human rights law.
No.
And their policy, right?
That's a given.
And their policies.
And their policy.
And their policies too. So we like all of our counterparts.
That's a given. My point is, in the executive branch, every agency is required to have a sexual harassment policy. And the way the training works typically is that if you believe sexual harassment has occurred, the first avenue of recourse typically is to the agency policy for a very good reason. The goal is to provide the promptest, most effective, most immediate relief possible. And you take it directly to the employer who has the ability to remedy it. So that's where I'm starting from. Of course, they have to adhere to the state human rights law. That's a given. But I'm still trying to figure out, maybe I'm becoming obsessed with process, but I think if you're not thinking through the process, you're going to be asking these questions potentially at an inopportune time. I mean, is there an order of priority that we envision for when or which forum? And I'm never going to say fora here. I'm going to say forums. Which forum you go to first? I mean, again, there's this existing presumption, unless it's changed, you start at the agency level. But can a victim bypass the agency and come directly to us? What do you do if you've started it in the agency, but the agency's taking too long and you decide to come to us when they're dragging their feet? What do you do if you brought it to your agency and they ruled against you, and then you say, I want to go to the Ethics Commission now? What, if any, preclusive effect does a decision from the agency proceeding, or even if you went so far as to human rights or Title VII? I don't understand. It seems, again, this is looking at that material on the DOL website. It's all of a comprehensive structure, and we're adding a new element to that comprehensive structure. And I'm just trying to figure out where it fits.
All right, so in terms of preclusive effect, that happens to be one area of expertise from my old days of practice. Agency determinations, depending upon the standard of proof, can indeed have, in New York, has a long history of applying preclusive effect to agency determinations, even in individual tort cases. So that can occur. And maybe you see a little bit of that being raised by the third department in the debate that occurred when the Ball case, Ball against DOH, was argued. We have a different standard of proof, different elements from a medical malpractice case, say, to a claim that an individual, in that case an EMT, maybe didn't deal correctly with a patient who was being taken to an ambulance. So we have that kind of situation. Every claim that comes through this commission is a fresh claim. We do not have, they don't have to, claimants coming to us don't have to have right to sue letters. They don't have to exhaust other remedies. That is not our mission. Our mission is to be there to receive complaints and to investigate, frankly, to self-initiate when we see a situation emerge where the Public Officers Law, Section 107 of the Civil Service Law, or the Lobbying Act is being violated. We don't say, take it someplace else first, necessarily. Now, we may have instances, I don't want to go too far down that path. We may have instances where we think something could be more efficiently and effectively dealt with if an individual is having a concern by their agency or by another entity. So and the commission has the power to refer. The commission can refer by vote to a prosecutor if we think a criminal violation is involved. We will, in instances, perhaps suggest that an individual coming to us with some problem that's affecting them that maybe does or doesn't violate, because we haven't investigated it yet, may or may not constitute a violation of a statute that we enforce. We may say, have you gone there? Have you gone to that other place to get recourse? I have talked about, it's not in our legislative agenda yet. I've raised the question, and I think it'll be one of the comprehensive review issues. Should the commission have the power to seek emergent relief in court, for example, whether independently or through the Attorney General's office, when we see a violation in motion? I think what you're getting at is, it does take us a while to process claims. So if you've got something that needs to be addressed quickly in the workplace, we can make phone calls. Our investigative unit is very good getting commission permission to make relevant outreach and try to address situations. But there's nothing in our statute that comes to mind. I don't think I'm overlooking anything. I don't think I'm overlooking anything in the regulations. There are instances where individuals seeking permission for certain kinds of activities will have to go to their agency head or ethics officer to get their consent before coming to us for permission. So we do have that for certain kinds of activities. And if they don't comply with those requirements, they could be, if there's an underlying conflict, getting themselves in POL 74-3 trouble.
And there might be
That could
situations.
happen, or 73-5. You know, there are any number of issues that can be emerging if they don't seek that first. But so that's an instance where you have to go there first, don't come to us. But apart from that, in terms of our enforcement powers, no, we don't have a requirement that individuals exhaust other remedies before they come to us. You know, recognizing that our process may not be as quick as recourse to other agencies, whether it's in the case of a workplace issue, whether they'd be better off
Is that your concern, Nancy? Is that
going to
your
OER.
question?
It is a concern of mine, Dolly,
Okay.
only because when you think back, put yourself in the position of the victim. Something has happened that has altered the terms and conditions of employment somehow.
Right.
And it's taking place in the workplace. You go to that workplace every single day. Your goal is to have it stop. Well, have it be known and have it be stopped as promptly as possible. That's always been the policy behind the requirement that you go first to your employer, the person who knows most about what's going on. And even though they're typically thinking about it in terms of potential employee misconduct, and we're thinking about it as an ethical violation, it seems to me you want the relief, the avenue of relief to be the quickest possible there is. And to have a circumstance where a victim could conceivably come to the Ethics Commission before going anyplace else, I think does a disservice both to the victim and the nature of the workplace. It's kind of putting the employer on its left foot to say, wait a minute.
Well, but
This is
there
the
might be
first
situ-
I'm hearing of it.
But there might be situations where that's not an avenue for you, depending on where the workplace is. And so this provision, I mean, this has been available to any employee always to come to us and claim that someone is violating the public officer's law by engaging in sexually harassing conduct. That has always been the case. I don't think having a definition like this changes that. So
this is no longer a definitional question I'm raising. My concern is not the definition per se. I just wanted it to be uniform. My concern is the order of process.
Okay,
Where you go first, because I think that's
Okay, one
just
second, I'm sorry, one
that's a
second.
policy question.
Right, okay,
That's
one
all
second.
it is.
It is a policy question, and one thing the legislature did in our statute, in NYCRR, is they added a provision that, at the very least, authorizes the commission to recommend and conceivably allows us to require, at the culmination of an enforcement proceeding, disciplinary action at the agency level. To me, that speaks to an intention in legislative policy to give this agency primary jurisdiction, if you will, not to the exclusion of other agencies. So not in the FDA kind of sense of primary jurisdiction, but not a secondary or a backup or a fallback or an after exhaustion of other remedies jurisdiction, but a primary jurisdiction to be concerned with, to hear complaints, to be sensitive to issues that individuals who maybe are not, maybe haven't pursued, but maybe are not getting satisfaction or relief from their employing agencies, or if they're not, or another agency that maybe they're not employed by the agency, whose employees' conduct is impacting them. But we generally have not, I don't want to overstate it. I mean, there are instances clearly where individuals will come to us, maybe because they're ill-informed or for other reasons, asking us to do something that our enforcement staff will think maybe can be addressed better in a different way. But that doesn't mean we turn them away and say you have no recourse from us. If we think there's the predicate exists that subsection 10 of section 94 requires a sufficient reason to think that there may be a violation of the ethics laws taking place, I don't think it's our place to say, no, you can't come to us at all.
So
We try not to do that.
I just want to get to other people as well, so,
Sorry,
yeah.
I just want to clarify.
I'm sorry.
Jim has his hand.
Yeah. So let me just take a few other people and we'll come back if we have to. Jim?
Thanks, Dolly. Yeah, so I just, you've all heard my concerns. But I want to just summarize, I think based on my last couple of days working with staff, sort of where I'm at. And first of all, I want to say, I
Give
think
me 1
sexual
second.
harassment.
I'm sorry, 1 second. I apologize. We're gonna do this here. Question B.
If there's
I'm
a
not
legal
sure.
issue,
Okay.
we can.
Is this a
adjourn to-
legal issue or is your concern that you're raising, is that a legal issue or is it?
I don't
I just want to make
think
sure that,
so.
where we're talking. Huh?
No.
Okay, go ahead. Sorry, I just want to make
Um,
sure, because I heard different, yeah.
So, I think sexual harassment and other forms of discrimination are really important. And I think most of those kinds of cases should and are within the jurisdiction of the commission. But the concerns I've been raising, and I think, working with staff the last few days has helped me sort of crystallize them. And Nancy hit on this, is first, should our jurisdiction be exactly coterminous with that of a sexual harassment policy? So that's question number one. And question number two, if it should be, then shouldn't we have the same powers to act in a less adversarial manner, and do things like require training and inform the agency of what's going on, just like the people who enforce these sexual harassment and EEO policies do? And so those are my two issues.
Okay.
And I'm not 100% sure that this rule, gets us there.
Gets us to
A place where if, that we've decided exactly what should be within the bucket, and then that we have the same tools that an agency or a Office of Employee Relations would have to deal with everything that's in the bucket.
I get it, okay. Sandy? Or Michael? Yeah. I mean, certainly, an employee goes to different agencies.
Dolly, I can't hear you.
I said, certainly, individuals go to different agencies for different relief. Our agency does not, we're not penalizing the employer like you and you wouldn't get damages like you would, for example, at the HRA. And going to your employer might be an option, but it might not be an option. So I would, I wouldn't want that to be an obstacle to somebody coming in. And then the question is whether we're allowed to do the kind of remedies that Jim is suggesting. And so I'm going to give that one.
Well, yeah. I mean, we're obviously limited in the remedies that we can employ. So I was saying, we talked about this before. We can't award back pay, front pay. We can't require people be promoted. We do have additional powers we didn't have before. So in addition to the penalties that are in the PLL, the monetary penalties, as I said, we can at the very least recommend some kind of discipline of individuals. We have a process, though, that we have to go through, which may be more complicated than other agencies have. And we know for file litigation, courts are not going to be receptive to our circumventing those. We do have the provision for simplifying procedures in certain kinds of cases that I know that you're working on. Are we the ideal place for someone to come to who feels that their employment status, their progression in their job has been inhibited by certain conduct that's taking place? I would say, yeah, probably not. I mean, we're kind of, I don't want to say the last resort, because I don't think there's any exhaustion requirement, but we wouldn't be the first place one would go. if they felt they were being discriminated against in a way that required some sort of compensatory award or reward to them. Whether it be in terms of employment status or employment conditions or in terms of monetary losses they've sustained. We just don't have those kinds of remedial powers. And again, we don't necessarily have the ability to jump in
Right.
and get somebody, emergent relief.
And by the time we got, not that by the time we got through, because of the process and the time, no one's risking their statute of limitations to wait, to see what happens with us. Not that it takes that long, but there is a process that we go through investigating. I guess you're asking though specifically about whether we can order training and whether we could report to employers.
Yeah, I mean, I feel
I'm sorry. Okay.
this isn't for lack of empathy, but if somebody picks us over the Human Rights Commission or the Division of Human Rights, then they have to know they're not going to get money or back pay or something, obviously. But on the other end, if there's a less egregious thing that doesn't warrant, where there's no employment decision involved that we could remedy, but that would warrant a day of training for the perpetrator, we can't do that.
Well, I don't
I got
necessarily.
you and I got Ava.
Oh, I'm
Just
sorry.
1 second. No,
If I'm gonna-
finish the answer.
Yeah, I
and then I'll
don't
move on.
necessarily agree, and we've had an internal discussion in another matter that has nothing to do with sexual harassment. I think we can, in the context of a resolution, require training. I think that's within our power.
I meant when I said we can't, I meant it's, and I shouldn't say we can't. It seems a lot less clear that we can do that outside of a settlement context.
I'm just going to turn over now to Commissioner
I
Austin.
would love to be wrong about that. So I'm not saying, I haven't done research, and if that's something we should talk about at another time, fine. But that's my concern is that
a little more in executive, if we go into an executive session, just to
that
talk
my
about
concern is that if we make it, if we make our jurisdiction exactly coterminous, then we need to make sure we have all the tools we need. And I'll just raise another issue that a commissioner raised to me, and I don't know the answer to this. With the language in the rule saying that someone suffered sexual conduct or words that constitute sexual harassment to occur in the workplace or in a work-related event, does that extend us to the level of, a supervisor failing to report? Because most policies would get to that and would consider that something that somebody could get retrained on or could might get in trouble for or might get reprimanded for. Are we taking cases where there was a failure to report? I'm just not sure of. I just want to make sure we all know what's in the bucket.
I kind of would think that we are, but I'm going to turn now over to Commissioner Austin, who has his hand up, and then we'll go to you, Vice Chair Ayers.
It seems to me we're talking more in terms of how to communicate and agree to an agreed party where to go and what their choices are, which really has nothing to do with what we're doing with 940. Excuse me. Once we make a decision as to how, if at all, we're going to bring 940 into the world, then the issues that we're discussing now will be, if you want to go to your local guy,
Process, procedure.
ethics officer, if you want to go to the inspector general, you want to go this way, you go that way. Here are the steps. Like will it take long? You know, and you do it as a pamphlet and let the people understand what they're getting into with each option that they have, and let them take their options and give them where to communicate with any one of those options. That's not what I thought we were talking about today. I thought we were talking about whether or not we should create a 940 that will deal with how we handle it when and if the case comes to us, which is and if we would, whether it falls within our jurisdiction, and whether how we handle it, you know, from soup to nuts. That is a different conversation. I think we've terribly veered away from that to the discussion of telling them where to go and what to do.
Thank you. Thank you. Putting us back on track a little, just to, you're right. First things first, let's talk about whether we're going to have this on the books. Commissioner, Vice Chair Ayers.
Thanks. And yeah, this is along the lines that Commissioner Austin was saying. I think it'd be helpful to focus on sort of substantive concerns that people have that they would see as sort of reasons not to adopt this reg, and I'm sure we'll have drafting suggestions if we proceed to adopting it. My thought, for what it's worth, is that on the questions about parallel enforcement by other entities, which I think are important and useful to talk about, I guess I have two thoughts. One, I think we frequently have questions about how other agencies' investigations or processes overlap with our procedures in many kinds of cases. So I don't think that's unique to the sexual harassment context. I certainly think it's true, as Commissioner Groenewegen was saying, that there are sort of structures created within state agencies for addressing sexual harassment concerns that are unique, and we should be thinking about our own processes to make sure that they work in a sensible way related to those. I think that's true for other contexts as well. But of course, we won't get to that concern unless we actually want to adopt the reg or continue enforcing it in the way that we have. And for me, the key thing there in terms of parallel enforcement is that I think of our agency as vindicating a different interest than the employment policies or civil lawsuits or criminal prosecutions that one might have. That, you know, when you're talking about a public official engaging in sexual harassment, there's a victim, and the victim is the person who should come first in terms of the concerns that any agency is addressing. Our role, as I think of it, is to make sure that there's also a vindication of the public's interest in making sure that its officials are behaving in a way that's consistent with the public trust. And so, you know, some of the differences in remedies that are available may relate to that. And again, this isn't to minimize the concerns about parallel enforcement, because I think that the important thing is to make sure that we don't end up in a situation where the victim's interests are not being protected because COLIG has somehow snared the process. We absolutely should. But I also think that that's something that from what I've seen, that our staff is extremely conscientious about working with other involved agencies to make sure of, in the cases that we investigate and pursue, and that there may not be a one-size-fits-all solution to that concern. In other words, sometimes the agency itself may be part of the problem, and then you need a different route or a different approach compared to when the agency is sort of involved in an appropriate way and is conducting its own investigation. Maybe then we step back. But I think that for me anyway, I'm not saying anybody else needs to agree with me, but for me, they're somewhat separate concerns about how do we address the parallel proceedings and what should our interpretation of the law be. And the reason I say that is that I think we're perfectly free as an agency to say, look, on the one hand, it's our view that sexual harassment does violate the public law. That's our interpretation of the law. And then once we know that, and once that's clear enough to everyone, now we can talk about what policies we need to make sure that victims' interests are protected in proceedings. You know, do we need something formal, or are the existing precautions that staff generally takes sufficient to that? and that sort of implementation concern, this may be part of what Commissioner Austin was talking about, that the implementation concerns are secondary to the primary concern about whether our view is that the law is correctly interpreted in the way that the regulation does. And in my view, it is, but I know that there are other commissioners who have concerns about the interpretation. I think this is maybe partly what Commissioner Karras was talking about in terms of whether the buckets line up and all that kind of thing. So I wonder if it would be helpful to talk about people's substantive concerns with the interpretation adopted in the text.
Thank you, Vice Chair. Commissioner Scott?
Yeah, this is a background question, and it's sort of with regard to all of the issues that are coming up in this discussion. And that is, how do our regulations treat, say, racial discrimination or any other protected class?
Well,
The regulations don't specifically address that as a matter of policy. Any misuse of public position is something that potentially comes within the scope of our enforcement powers under the public officers law, and that has been the consistent approach of the agency. So we've had this discussion before, where there have been proposals to explicitly expand the commission's jurisdiction to parallel that, for example, of that of the of DHR. There's been less pressure to do that lately, and our uniform position is we don't need that. We don't need to have an explicit addition to our jurisdiction, because when we do see instances where public office is being abused, and whether that's manifesting itself as discriminatory conduct based on race or other factors, or on sex or sexual orientation, then the public officers law is implicated.
yeah. So certainly we think that's an ethics issue. I mean, I don't think anybody would disagree that discrimination in any form is an ethics issue. And we have talked about including that in this, but we're starting with this one. And the other part of it is the agency rules prohibit discrimination as well based on other factors other than sex or gender. But certainly something to take up, and it is implicated in here as well, and it is certainly a violation. But we're starting here. Did you want to? We did talk about doing them.
I should add that historically, the impetus for having a legislative codification of sexual harassment as a specific violation of the Code of Ethics of Section 74 is a longstanding one, and it reflects the fact that there's been all too frequent litigation of the Commission's power to act in that area. And it would make sense, instead of arguing afresh as to the Commission's jurisdiction, each time we take on a case of that kind, why not just have the legislature clarify it and be done with it, rather than having to. And we do have the power to interpret. The legislature has given us the power to interpret and administer the statute.
And they usually hand in hand. That's true.
But sexual harassment has been just a persistent issue that's come up from time to time.
Right. Commissioner Austin.
Just getting back to the substance of the proposed regulation. I'm curious, we define officer, employee of the state agency, member of legislature, and legislative employee, who certainly do come under our jurisdiction. But where's anybody in the executive branch? Aren't they under our jurisdiction as well? No mention whatsoever.
Well, with respect to those particular issues, I think we should circulate any additions.
State employee.
They're employees of state agencies, so that's
The
how.
governor is an agency?
Well, that's an interesting question. We're limited to the definitions that are in the public officers law, and the answer is yes. The governor's office is deemed to be for purposes
Executive
of 74. a state agency, and that's been the uniform interpretation.
Keith?
No, all I was suggesting was we've longstanding interpretation of the executive chamber as being a state agency, the equivalent of a state agency. If that's what the concern was, whether employees of the.
It is more from the public view of, that we've kind of left something out.
No,
It's one of the 20 departments defined in the Constitution, the executive chamber.
Yeah.
Or the executive department is one of 20, and the definition of agency in 74 includes departments. So that all this does is import the definition that's in section 74.
So does anyone have any questions or concerns about this substantively about the proposal?
I have some language suggestions.
I think, we'll see what our time frame is, because we do have the other proposal to go through. I don't know if we should do the wordsmithing here in a committee meeting, or whether we should, unless it's kind of minor and people get it in, or whether we should do it in advance of our next meeting, well in advance, so that we can discuss it. And I'm taking a poll on that. What's your preference?
I think it would be just as efficient, I think.
To do it here?
Depending on the volume. Well, or to exchange drafts. I mean, I think.
Yeah, because everybody could have everyone's changes and work on them. Any other concerns? I know that any other concerns, let me get the answer to that before I move on. With the members of the committee, I'd like to know whether you are recommending this to the commission, to the full commission for adoption.
Still working on it.
Are there words in here, or there's something in here that would prohibit you from recommending it? And if that's the case, then yes, then we should discuss those.
Are we going to discuss them and move on, or are we moving on to just exchange emails?
Well, no, I mean, if it's substantive and that would prohibit you from making a recommendation, then yes, I'd like to hear them now, because that's why we're here. I thought they were technical or minor, and I apologize for thinking that. So let's hear what would.
On the third page, paragraph B, I'm curious as to why proof is taken out and evidence is there instead.
That was my suggestion, because I think I think of evidence as what you put forward, and it's either proof of it or it's not proof, but it's not necessarily proof that you're putting in. It depends on. Do you get what I'm saying? So I don't put when I think of myself trying a case, I'm not thinking I'm putting in proof. I'm putting in evidence that's intended to prove something, and it may or may not prove that. So that's the reason I suggested that change. Anyone else have a comment on that? And if I don't see your hand, please let me know.
I'll say I use proof, but I'm not wedded to it. The reason for using proof is because in our procedures, the technical rules of evidence don't apply. That doesn't mean that the proof that's going in isn't evidence.
I see.
It's just a semantic thing. It has no real importance beyond that.
For me, in my mind, if you say proof, it means that it does show that it's and of course that's the only reason you're going to find there's a violation. But I'm not wedded to evidence either. Any other?
Yeah, 1 second.
While he's looking, does anyone else have any comments as to the language of the proposed regulation amendment? Ava?
Well, I just wanted to ask, I know during the meeting, folks were expressing concern about the question of what course of conduct means and whether a single incident can suffice. And I saw that Sandy's memo, I think, has a good long footnote addressing that concern in terms of the meaning of the law. But but I just wanted to raise that, not because it's my concern, but people had raised it, and if that's an issue that would prevent people from endorsing the current proposal, then it might be helpful to talk about it here. So I'm not raising an issue. I'm asking if others want to talk about an issue that they've
That was
raised
my
in the
other
past.
concern.
Okay, great.
Were you gonna talk to your concern, or is it at the same concern?
Yeah, and Ava, thanks for raising that, because, my concern isn't, well, I won't characterize it, but I did watch the training film that Sandy sent around, and I want to, for the record, thank him for sending around. I did find it very helpful.
I do recommend everybody watch that video. It's very helpful, and Jim in particular, I think you should watch that video because it goes through the instances. But go ahead, I apologize.
And it's put together by the Department of Labor, and one of the notes, one of the things they say in that is not a note, but it was one of their slides, says that under the New York State law, harassment can be unlawful if it rises above petty slights or trivial inconveniences. And, whether that belongs in our definition in the regulation, or whether that belongs somewhere in our, how our procedures that we develop. I think that that's an important point, and that would, provide me with a much stronger level of comfort. This notion that, just anybody's complaint of anything, can't be in and of itself considered sexual harassment. It does have to rise to a certain level.
Yeah, I think we should take that under consideration.
Yeah, let me say, I'm aware of that, and I agree it's a procedural issue. I think it's a matter of defense, and I didn't want to suggest that there aren't other defenses that might be raised, and I don't want to try to catalog what those might be, and it could be deemed limiting. And so I thought leave the field of defenses to the procedural determinations in individual cases by the hearing officer, rather than spelling out and potentially omitting some defense we hadn't thought of.
But you convinced me the other way now.
But I could go either way.
Maybe we could put it somewhere like but I hear what you're saying as well. Len, did you want to raise anything?
On the next page, F.
But we'll talk about
And here we have the definition. Excuse me. Makes an unwelcome sexual advance or request for sexual favors or engagement in verbal, nonverbal, or physical conduct of a sexual nature that creates a hostile, intimidating, or offensive workplace, or suffering or permitting others to do so in the workplace or at workplace-related events. And that conduct gives reasonable basis for the impression that any person can improperly influence him or her, etc. So do I understand this to mean that the burden of proof on behalf of the petitioner, the alleged victim, is to show that one of these things was done, one or more of these things was done, and assuming, and they've met that threshold, do they then have to meet a threshold that it created a hostile, intimidating, or offensive workplace, or suffered to be permitted that situation?
no, it's or this or that, not all or and, it's or.
Well,
so you can show.
Oh, no, I'm saying any one of those things.
Right.
Once they've established one of those things, or put it another way, does the burden of proof require, in effect, where your highlighting comes in, your red comes in, Dolly, after 74, probably Robin at 1 or A, makes unwelcome to conduct, and
you mean subdivide it, add subdivisions,
right,
okay.
and creates a hostile environment.
Or we want
No.
no.
Well,
I mean that.
if I create,
Let's talk about it. But
if I create a hostile atmosphere because you like the Ravens and I like the Giants, it has nothing to do with sex. We could have a dispute about the best baseball team, that anything. That has nothing to do with sex or sexual harassment.
Well,
And it would create a hostile incident.
but it makes an unwelcome sexual advance or request or
Right.
engages in.
They're
I
disjunctive.
get you.
They're disjunctive.
Are they really?
Yes.
I don't read it that way. Because I would say that one would, if I was sitting and hearing this case, I would say that the complainant has to establish, A, that there was some kind of unwelcome sexual advance, et cetera, and that created a hostile environment.
So we could put
No.
semicolons.
In other words,
No, I understand.
Or
in other
little
words,
1, 2,
if I,
3.
for her birthday, when I came up behind Ava, said, gave her a little kiss and said, "Happy birthday, Ava." She said, "Thank you," and we walked away. No tongues, because that we had that problem. Just a simple act that one could argue with, depending on sensitivity, I should not have done, but it doesn't create a hostile environment. I walk away, nothing ever said. I never do anything. There's nothing retaliatory. Just, I'm sorry, I got into your space, and we go on business as usual. That doesn't create a hostile environment. I may have done something that was ill-advised, but that's not a hostile environment.
No,
But there's no
that's-
requirement of a hostile environment. It doesn't have to create a hostile environment. It is,
Sorry.
I'm sorry.
I just want to point out that we are in public session, and I don't want to get into a full conversation about what is a hostile environment and what is not legally right now. If we want to have a more wholesome discussion
second.
about that, I think we can do that in executive session.
Yeah, I think Commissioner Austin is raising a good point that needs further scrutiny, and I'd rather like Rita suggest that we should carry that further exploration of the question and issue that he's raising in a different setting.
My
Thank
purpose
you
was
both.
not
Okay,
to,
thanks.
my purpose was not to define what it is, but rather, do we have one or two elements that need to be proven at a hearing?
Right.
That was my point.
They're disjunctive. The draft here is intended to be
Right,
disjunctive.
and
So
we
can
will
know.
put little
Not clear.
subsections on it
Okay, we
to
can clarify that.
separate it.
All right, because my view is that
I
you
understand.
you do need to prove too.
Well, the
HRL was amended.
video that Linda just mentioned earlier, I think goes through that very.
We'll talk about it later. I'm fine.
Okay, I'm just suggesting everyone look at that, and I think that's a good way to analyze whether or not there's a violation of this. I think it gives you a good roadmap. Jim, you have your hands up? No? Okay.
You're
Are
muted,
there-
Commissioner Karas.
We can't
You're
hear you,
muted.
you're muted.
I'm sorry, I put my hand down because it's legal related. It was a response to what the discussion went started.
All right, so if no one has any other comments about this, for now, I would
Yeah, I just-
suggest we
one last
adjourn.
Quick comments.
Okay.
The purpose of my raising it is to be sure that both sides of any claim get the same perspective, get the same burdens of proof and the ability to prove or disprove what's going on. So it's more to balance the process than anything else.
Great.
That being said, you want
Yes.
to adjourn?
Yeah, so unless anyone has any questions that you want to discuss here in public session, I would suggest we adjourn to executive session to discuss.
I thought we were kind of voting thing first.
We can come back in public afterwards if there's anything
Yeah.
else.
To discuss, what are we discussing in executive session?
To discuss legal issues related to the matter before the commission and legal advice. And I guess you take a vote.
I move we go to executive session for that purpose.
Second,
Please, not all at once.
is
Well,
anyone seconding?
I don't think I'm allowed to, I'm not a committee member, so
Commissioner Karas?
Jim
Yes.
can.
Oh, Jim, okay.
Could
Okay.
someone please
Okay.
send me the link to the executive
Yes.
session?
Yes. we
Thank
can do that. All right, thank you.
All right, see you over there.
Okay, good.
Thank you. Welcome back to the public session of the Cold Lakes Legislative Committee meeting. In executive session, we
Oh, yeah,
discussed.
in executive session, the commission discussed legal issues related to matters on the agenda concerning the sexual harassment regulatory proposal and the proposal with respect to changing the majority requirement for the commission.
Thank you. Are there any questions or concerns about the issues that we discussed, or are we ready to adjourn this meeting? All right, do I hear a motion to adjourn?
Wait, I'm sorry.
We didn't do anything on the second item.
Okay, hey, but that's your item. You didn't do it.
I was just going to say what Commissioner Austin said. Yeah.
I apologize. Go ahead.
I move that we not adopt the second item on the agenda with regard to majority voting. That we not adopt or recommend it to the full commission.
Jim?
Second.
So I think that's going to be a unanimous position from the committee that we are not recommending. Yeah, all in favor of not recommending. It's unanimous now. Thank you. Ava, is there anything you want to add?
No, I'm grateful to everybody for the thoughtful discussion.
Thank you.
You want to say with respect to item 2, the proposed rulemaking, staff will be redrafting and circulating a further draft of the proposal for consideration by the committee.
So in case you didn't hear that, staff will prepare a further draft of the proposed new regulation 940 and will circulate it to the commission. Thank you very much. Thank you, everyone, for joining the meeting.
What are we doing with item 4?
That's 4.
The,
Commissioner Karas, we discussed it a little bit.
Okay. So with respect to item 4 on the agenda, which had to do with alternative processes, we're going to table that discussion for another committee meeting.
Move to table.
Can I second?
Commissioner Karas?
Commissioner Karas?
Sure. I would like to say, I would like to get as definitive an answer as I can on what our powers would be to share a.
Oh, man, I'm sorry.
No worries.
Sorry.
It's okay. We're sorry. Go ahead.
To share a guidance letter if we close a matter with guidance with the agency. And if there was a way we could direct or urge the agency to get training for whether it be ethics training, discrimination training, harassment training, where we see that somebody may have crossed the line, but it's not a big issue. I'd like to get sort of definitive as we can answers to those questions.
What?
There are 4, 5, or 6.
Yeah.
Thank you.
I agree.
Stan,
Staff will do some further research, and I know Commissioner Karas, you've been working with a staff member as well.
Yes, and like I said, Jen sent around what I thought was some very informative materials. I know she's and I shared them with you all. So I look forward to getting more feedback.
great. Thank you.
We'll follow up.
Thank you, Commissioner Karas. All right, so we're going to entertain a motion to adjourn this meeting. Do you need one?
So moved.
Not on the committee.
Okay. All in favor?
Second.
Aye.
Aye.
We are adjourned. Thank you all for joining us.